Hi, I'm Jim Doyle from Doyles Construction Lawyers, and here to talk to you today about latent conditions. Latent conditions are very important in the construction industry, which has to take the rough with the smooth and some way work through some of the unexpected risks inherent in construction latent conditions. So with this seminar, what I want to cover is latent conditions. What are they? The law around latent conditions, how contracts wrestle with the latent conditions, and then disputes in commercial situations at the end. So we want to have a look at latent conditions from a position where we're not intimately involved in a big dispute at the moment, but we look at latent conditions and can see how we can avoid them in future and manage them when they do occur. What is a latent condition? Why are they important? A condition usually on site that have not been contemplated by the parties. So the big issue is that if they haven't been contemplated, they haven't been planned for. If they haven't been planned for, they're uncertain, unlimited necessarily in extent, and likely to be a matter of contention between the parties as to who pays. The concern is that if the parties start fighting over the latent condition and they're not aware of who's paying, then the management on the cost will be disrupted and unmanaged. Alternatively, latent conditions can be conditions on site which have been contemplated but have not been provided for appropriately in the contract. We'll see some examples of that later on where people have imagined that they might strike some rock, but they haven't actually provided for it in a way that will allow them to manage it within the contract. Now, if we go on to discuss latent conditions, they're hidden and unforeseeable based on the information reasonably available before the contract started. Now, of course, it is the advice of the wise is to make more and more geotechnical inquiries, and that might remove the risk of, say, rock. But principals particularly don't want to invest further money in surveying something that's not usually there, so they often cut down on those surveys. And what you find in a general construction job, whether it's for a building or a road, you find bore logs at widely spaced intervals. And the usual gossip in the industry is the bad conditions are anywhere except on the bore logs. One of the risks in terms of latent conditions, particularly prominent in Sydney recently, is asbestos, because asbestos has caused schools to be shut down, inquiries to be put into the distributors of covering to gardens because of the fact that it might be contaminated by asbestos. And the problem with asbestos is, even if you only have a small sample of it, it's a situation where it's still very dangerous, and people want to put a complete bar on having anything to do with asbestos. The other aspect you've got to look at is patent conditions. Those patent conditions, usually, if they can be discoverable during a site visit, documentation review or standard diligence, then they're much more easily controlled. If there's rubbish piles visible at tender walk through, then they can be taken into account by the contractor and priced for removal. The legal distinction is crucial. Typically, the contract only allows for the conditions it contemplates and then has a provision which hopes to catch most of the latent conditions. Why they matter is because latent conditions are traditionally expensive. To remove something that you've planned for that you put in a tender for, that you've recruited people to consider and plan for, is usually effective and efficient. Additionally, you've had the chance to subcontract the removal of the condition you planned for. The subcontract that's been selected is usually the most efficient and qualified and talented, and he's had available in his work schedule to fit that job in. On the other hand, if latent conditions are encountered, there's no notice and there's much panic. So latent conditions commonly cause cost blowouts, extra excavation, dewatering. One job I was involved with was the Brisbane airport, and there the contractor ran into bore logs that were accurate, but between the bore logs, the ground conditions varied between clay and sand. So 10 feet distance, he was in sand. The next he was in clay, which had risen up 2 metres. He had to dig through clay and then he got into sand again. The problem it caused is that he got no efficiencies of operation and had to change his equipment and method of operation at very frequent intervals. And as a result, a large claim developed. The other aspect that happens with latent conditions is program delays, because even if you were lucky enough to avoid a massive cost overrun, it's highly likely that you'll have delays as subcontractors scheduled to do work can't be allowed access, and new contractors to deal with the latent condition claim come into being. So the extension of time claims are significant, and disputes between principals and contractors over entitlements and liability leave them blaming each other and expecting that somebody else is going to pick up the tab, and accordingly the tab's not too well managed and it's ignored by the party who's not bearing it. So the situation is in tender pricing, in insurance, and in contractor due diligence. You've got to look at these aspects and take them into consideration. So then we should look at the traditional common law position. The risk lies with the contractor in a lump sum contract, unless the contract expressly states otherwise. So if you have signed a contract to build a building on a site, then it's your problem to get the foundations at the level that they need to be. So the contractor bears the extra cost unless he has something in his contract to shield him from that exposure. The standard forms have moderated the traditional approach to some degree, and AS 2124 seeks a balance between what a reasonably competent and experienced contractor could have expected and what he couldn't have expected. And what he couldn't have expected is a candidate for having a lump sum accommodated by virtue of variation broadly at the cost of the principal. So the modern contract tries to seek that balance, but in recent times there have been projects which we've seen around recently where the principal has put all of the risk on the contractor, and at a onerous level where the contractor is expected to experience all of the risks of looking at the land, understanding the history of the land, understanding the previous excavation or construction on the land, and taking open-ended risk. Additionally, in some of the more onerous contracts, they're backed up with an indemnity clause. Contractors have to be aware of it. If you get caught, it'll be difficult. I worked for a contractor down in Melbourne, and years later I met him and I said, "Why'd you get out of contracting?" Well, he said, "We nearly went broke, we hit rock, lucky we had a clause in there that protected us, but we quit." And I said, "Where'd you go?" And he said, Well, I went to pumping petrol at a petrol station, and there, if somebody nicks off with $20 worth of petrol, the cops stream after him, arrest him, and you get your $20 back pretty quickly. Whereas if you hit rock, you just go broke. So it's important that the risk is identified and properly taken into account when you're pricing things. Buried contaminants are a massive problem, because if you hit a site that has been contaminated heavily with fuel, it can cost millions to remedy it. Underground services, which have been omitted from records, are another latent condition which should be taken into account, and somebody should take expressly the risk of it or exclude it. The important aspect when you're doing contracts to have express inclusions and express exclusions, and to make sure that you know clearly where the boundaries lie. Again, unexpectedly high groundwater table can cause enormous difficulty. Perhaps you're constructing a tunnel, perhaps a deep excavation, a car park. If you have unexpected water ingress, you'll end up in a difficulty. Archaeological remains, if you happen to come across some sort of historically valuable remnant, then of course your project will be stopped for large time and at large cost. And of course, in home building, collapsible or reactive soil types have got to be looked for. Doing contracts for a builder recently, and he said, we just don't build if the soil's black. We're not interested in it, we don't go, we terminate the contract. That's his attitude in the way he conducted his business to looking at the latent conditions. Given that the contractor takes the risks, and given that the courts will not usually on the contractual basis reallocate that on a basis of fairness or reasonableness, the situation is, the key issue is there a specific latent condition in your contract? Does it say what you can't find, you don't have to cost? Are there exclusion or disclaimer clauses on the information that's been provided to you? And if the principal's relied on other people to get advice and he's just passed it on, was that reasonable? Again, another matter come across, somebody does some geotech, they want to organise it a long way ahead of time, and they rush through it and get some results out, and the geotech says the value will be X. It's designed on that basis under a harsh contract and eventually collapses. And that's because wrong geotech information fundamentally was provided. So again, it's very important as a contractor, unless you're a D-Tech as well, and even if you are, to make sure that you're making your price contingent on the information that's being provided to you. The other aspect is, as an example of a fixed price contract, you've got this contract back in 1929 when the world was young and people were just getting out of the Depression, and the contractor encountered a greater volume of material than the tender documents indicated and sought additional payment. And the court's judgment was, no, it's a lump sum, bad luck. The contract was an entire contract to build the wall for that price, and the plaintiff's obligation was not affected by the information that he'd been provided or the assumptions that he'd made. He took the risk, and the court thought that he should bear it. Again, you've got large contracting companies who are involved in adverse ground conditions, and they thought that there might be a term could be employed to compensate them for it. That is, they'd sort of implied term that the ground would be reasonable, an implied term that something else would sort of alleviate But the judgment was no term was implied, express provisions governed it, and therefore a party who'd contracted to contract on that basis was bound to satisfy themselves of the characteristics of the land both on the surface and below it. So you've got to be careful. You have been warned. The law is pretty tough on that basis. Here you've got a little bit of an alleviation of that, where Sir Maurice Cudson in the Commonwealth, 1972, contractor relied on the geotechnical data in the tender and turned out to be inaccurate. Was the Commonwealth liable for the misleading information that was given? And there was a judgment there that the Commonwealth had failed to convey that they took no responsibility for the basic information in that material, and therefore the purported Commonwealth exclusion clause didn't bar the plaintiff's claim. So there's room, if you can look at the clause carefully and make sure that it doesn't cover exactly the problem that it's meant to exclude, then the situation is you might be able to get some release as a contractor. But it certainly needs care and attention from a contractor to preserve his scope. The other aspect is that talk of a situation where we talk of frustration, because latent conditions are close to frustrating events. A latent condition is a condition which is uncontemplated by the parties, and also unexpected by the parties, and also uncaused by the parties. Some of those characteristics come close to factors which frustrate a contract. So Godolphin State Rail Authority was a important leading case in respect of frustration, and regarded as having expanded the law of frustration significantly. And that was a case in the eastern suburbs of Sydney, where a contractor was tunnelling a railway tunnel to provide for a railway line. It expected that it would be able to work 24/7. So it priced it and resourced it on the basis that it could do that sort of heavy load. However, after it started, the adjacent residents who are concerned at their noise level took out an injunction to stop them working more than 12 hours a day. As a result of that, the court, and it was at the High Court of Australia, decided that frustration had occurred. The contract, the whole basis of the contract was significantly changed, and the contract was frustrated. The situation is that frustration occurs, said the court, whenever the law recognises that either party had a contractual obligation which became incapable of being performed in the way it was contemplated, because the circumstances render it a completely different item from what was undertaken. And that on that basis meant a large recovery for the contractor. The gossip is that whereas the contractor would have settled for 2 or 3 million, he ended up getting in those days 12 million by way of compensation, given the massive effect it had on the project concerned. For the other aspect was other cases which have dealt with latent conditions, and looking at this one of T Services and Mirvac Queensland Proprietary Limited, here the contractor encountered soil conditions which required excavation, and was there an implied entitlement to additional payment? And the judgment again was no. It had allocated the excavation risk, and the situation is Justice de Jersey, who's a bright and smart judge, led the judgment. He said that if the contract would otherwise bear this construction, a term should relieve the applicant from the absolute problems of remediation. And by the express terms of the contract, the appellant was obliged to secure that result efficiently and safely. The latent condition clause means the applicant was entitled to no extra payment because the work may prove more expensive than expected. So it's important to understand that just because the work will be more difficult, the conditions will be more onerous, and the resources required will be much larger, they'll not have sympathy from the courts. The aspect that comes into these cases in recent times, and I use the recent times as a lawyer would use them, which is, anything within 60 years or so is a recent time, but the impact of the Trade Practices Act 1974 in this area has been very significant, and very significant in most areas of commercial trade generally. It says that no person shall, in trade or commerce, engage in misleading or deceptive conduct or conduct which is likely to mislead or deceive. So it said we've all got to be non-misleading. And the importance of that is that it overrides contracts. So if on the one hand you have in your contract and somebody agrees that they'll accept all the latent conditions, but in fact you provided them with misleading information as to the extent or the risk of latent conditions, then if that misleading information has misled them, they will be effectively let off their undertaking. So Abigroup and Sydney Catchment Authority is an example of this. Abigroup were awarded a lump sum contract to construct a new split spillway dam. The tender document stated no plans existed for a certain outlet pipe. So the situation is that there were no plans that mapped out the extent of the lowest part of the excavation. But the situation is that there was some unexpected excavation required, 180,000 cubic metres, and the contract expressly allocated latent condition and documentation risk to the contractor. So the issue came up was, did the failure to disclose the 1951 pipe plan, that is, the plan of the earlier excavation that would have to be removed, did that failure affect the rights under the contract? And did that contract override express risk allocation clauses? Well, the Court of Appeal found for Abigroup, they found for the contractor, they said, no, that misleading information misled the contractor and is therefore entitled to the extra cost that he was required to incur. And the Sydney Catchment Authority was liable despite the clauses they put in their contract. So it's an important case. It's a very usual case. It's a very standard sort of remedy, and principles when inviting tenders and calling for people to put in prices have got to be careful that they don't provide misleading information as a basis. The damages awarded were approximately $7.5 million, so it meant a bit of money to the contractor and the principal. It's worth having a look at the examples that are used in respect of latent condition clauses. If we look at AS 2124, we can see that its latent conditions are physical conditions on the site or its surroundings, including artificial things, but excluding weather conditions, which differ materially from the physical conditions which could reasonably have been anticipated by the contractor at the time of the contractor's tender, if the contractor had 1. Examined all information made available, 2. Examined all information relevant to the risks and contingencies, and other circumstances having effect on the tender and obtainable by reasonable inquiries, and then inspected the site and its surroundings, and any other conditions which the contract specifies to be latent conditions. So there's a fairly high test in AS 2124 that the contractor must have examined all the information the principal's given him, and also other information which he could reasonably have obtained. So it's a high bar that's set. If you look at GC 21, differ material from reasonably have been expected at the close of tenders, and any physical conditions of site, including subsurface conditions, but excluding weather conditions or physical conditions which are the consequence of weather conditions. So you've got to look at that weather exclusion. The weather exclusion says that a weather condition is not a latent condition, so therefore you don't get paid for it under the latent condition clauses. That throws up some interesting challenges in certain areas. If you're in North Queensland and physical conditions push you into the wet season, then the consequences of them are very substantial, and it's a large carve-out to exclude weather conditions from latent conditions. So you've got to look at what you're looking at when you price a job to make sure that you've allowed for those possibilities. So the other aspect about it is, what if there's a condition which you broadly know about, but you don't really know the extent of it? That is, you know there's some soft ground in terms of road payment. You know there's some deteriorated foundation conditions, but you don't know the extent of it. Then the situation is that the courts have to look at what are they going to do in this circumstance. That came up in a case of Downer Constructions in Energy Australia, where the adjudicator said, in my opinion, the inflow is far higher than and differed materially from what would have been anticipated by a prudent, competent contractor who'd viewed the pre-contract information. And then went on to say the presence of extensive horizontal features with significant groundwater flows between change this and change that should not have been anticipated by a prudent contractor who's looking at the job. So the situation there is they were prepared to say not only is the condition latent, but its extent and the significance of its extent may be latent. So it's an important aspect when you're in a job. If you hit something that's awkward, then there might be some concern. So again, you've got another case where there's no entitlement. Contractor should have based it, should have performed diligent inquiries. So it's important. The other question is, reverting back to Walker in the city of Randwick. Here, in the old days, in 1929, the contractor was out without a prayer. That is, that he was expected to have contemplated doing the whole job, no matter what. But if it had been a situation that had been operating under the ACL as it is now, and that is that a person, perhaps that would cover the council, shall not in trade or commerce engage in misleading or deceptive conduct. What would it have done to his claim? And the situation is that if a party to a contract makes a representation about something which says, look, there's not much digging to do here, the rock's pretty soft and it'll come away in your machine easily, then that's an issue. If the other party relies on it, you must rely on it to be able to recover on it, and the representation turns out to be false, then the person who relied on the representation may have a claim under the Australian consumer law. It's a very important saver for many contractors and principals who otherwise would be without a remedy, notwithstanding that somebody had told them a misleading piece of information or misrepresented the future, saying, well, don't worry about that because X is the situation and I'll always be able to fix that up easily in the future. I've got the people and equipment to do it. And then when it happens, he's got not a wing or a prayer. So the other aspect is that's demonstrated the need for reliance. So that means when you're doing your tenders and you're putting in a tender for 100 houses to be built for the government, you must record your reliance on the information provided. So in this BMD major projects, the Victorian Urban Development matter, BMD contended and he accepted that the exclusionary clauses cannot override the statutory prohibition on misleading or deceptive conduct. So I agreed that if you were a contractual situation, the clauses of the legislation overrode the contract. But the circumstance was that BMD did not show that they relied on the misleading information because it had said in its correspondence it's used its own figures and information resulting from its own calculation in its tender. So you've got to be careful not to exclude the possibility of those remedies by expressly stating or in fact relying not on the misleading information but on your own guesses, because they won't have the same recovery value. So other ways in which latent conditions might be recovered, that is, if you've hit a latent condition and it's a bit awkward, and again under a contract, in this case of Walton Constructions in Illawarra Hotel, it's a case where Waltons were entitled to significantly more EOTs and variations, and they sued the principal for failing to ensure the superintendent acted reasonably. The superintendent was supposed to act reasonably under his contract. He'd certified very little for these things, and the question was then, was the principal in breach for failing to ensure that the superintendent had acted reasonably? And could this lead to time being at large and other aspects on the contract? Well, the situation is that McDougall J, usually tough judge, and in this case he went in favour of the contractor because he said even if the superintendent acted honestly and reasonably fairly, failing to make reasonable determinations breached the contract. That's what he was promised under the contract, and that's what hadn't been delivered. So McDougall said, well, the situation is that there's a recovery on that basis. The situation there is that it promotes the common sense aspect that in most contracts, fairness and reasonableness will probably get you home, but it's not something which you want to back the farm on. You can't do every contract and bet the farm on. So the situation is that the question was, even if the superintendent had acted honestly and reasonably, Walton could not be bound by her determination if it didn't meet the description of a reasonable extension of time or a reasonable measure of value. So it was one in which the contractor had narrowly survived what was otherwise a problem for it. The situation is that this is another case where you've got a consultant liability for design-induced latent condition. So here, they engaged the Lane Codes Council, engaged a consultant to design a stormwater detention system. However, construction revealed that the design failed to detect the latent condition. Obviously, it had been set up to go in a direction where the ground wasn't strong enough to support, and therefore it fell away, and therefore the contractor had to expend monies to protect itself, and the principal was exposed. And the issue in that case was the design consultant negligent in failing to detect it? And next, was the risk reasonably sort of foreseeable, and did it fall within his duty of care? So the situation is that the Supreme Court held that Michael Davies had breached his duty of care, as a competent consultant should have conducted or recommended adequate geotechnical investigations, and the MDA was liable for the council's loss arising from a failure to detect the latent condition. You'll have to be careful in these cases where you have a designer, where you have a professional designing, to get an accurate measure of the damage. In this case, for instance, the damage would not be the problem, not be the cost of responding to the latent condition. It wouldn't be the whole cost of rectifying the site instability. It would be the extra cost that was caused by the fact that it had to be done in a hurry while a contract was on site, rather than being done at leisure when more competitive bids and arrangements could be organised to cure that. So it's important when you have a consultant who has breached the duty of care to accurately calculate the damages that he can logically be required to bear. I wanted to just summarise again the Trade Practices Act history, because for contractors who get caught to latent conditions, that provision is of prime importance. It started off life in the Trade Practices Act 1974 as Section 52, but it's now part of the ACL at Section 18. That doesn't matter. Its effect is still the same. And the case law under the TPA continues to be highly relevant to construction disputes. It's important in every construction dispute to trace out whether or not somebody has engaged in misleading or deceptive conduct in order to establish liability. And the examples of those could be covering up defective work and building over it, making comments about the design life of various installations when that's not right, or otherwise misleading a consumer or a proprietor as to the compliance of the various installations with various regulations. An example I was involved in was a designer had designed a building which would have a 6-star rating, and that was a very attractive rating, and that was beneficial. The builder owner then built that dwelling, a very substantial, expensive dwelling, and then sold it on the basis that this was a building which had a 6-star rating. Well, when the purchaser found out that it wasn't performing to that extent, it wasn't properly designed and constructed to achieve the thermal installation that had been promised, in particular the amount of airflow that flew in and out of the house was significant and affected the heating costs, etc., then a primary cause of action was action under the misleading conduct provisions. So it's an important obligation that applies in a wide range of statutory and commercial situations. We've got to look at how contracts can interact in this area. Contracts can limit claims, but they can't contract out of the trade practices responsibilities. It includes by principle representations about the site or the aspects of the perhaps access, or a representation about the approvals that it has obtained, or the concessions it's obtained to depart from certain standards. The courts will consider the entire contract and the documents, not just parts, and they'll come to a proper assessment of to what extent, say, a principal has misled the contractor as to the terms and conditions of his contracting, or alternatively, how the contractor has misled the principal about his capacity and his ability to discharge the works that he's tendering for. So it's an important aspect, and it's an important warning to parties to make sure that they don't overrepresent their competence or capacity or the time it will take them to complete the works. So looking at some related legal documents, you've seen we've talked about frustration, about the fact that if the performance is radically different, then somebody might be excused from the responsibility of a latent condition. They're rare in construction because the courts expect the parties to allocate responsibility sensibly, and frustration must be not self-induced. That is, it must occur without the fault of either party. The classic case of frustration was when a ship, which was subject to a counterparty to carry goods in certain directions, was possessed by the government, who took it over and said, no, we wanted this for the war effort, in which case the court said, well, he hasn't got the ability to perform the contract, not through a fault of his own, and accordingly the frustration was one doctrine which allowed him some relief. So the issue here in this next case, all disputes over things that have not met the expectations of the parties. The DDI as a subcontractor to ProBuild was delayed by variations directed after the contractual period. It failed to claim EOTs within the specified timeframes. The contract allowed ProBuild to unilaterally grant EOTs even when they haven't been claimed. So the situation is DDI should have claimed it. They should have put in claims all the time. However, the situation is there was ability in ProBuild to unilaterally grant extensions at times, even not claimed. The issue for the court was ProBuild obligated to exercise its discretionary EOT claims to give some relief to DDI? Was there an implied duty of good faith to require ProBuild to take that action. The problem, of course, was that the courts are loath to imply a duty of good faith because it's hard to define the extent of it, and it is said to induce confusion into contracts. Contracts are usually cut and dried. Usually it's like old Shylock. If you promised him a pound of flesh, then he wanted the pound of flesh that he wanted, and he asked for it. So DEI had some weights against them in trying to secure some remedies based on the good faith obligation of ProBuild. But the New South Wales Court of Appeal held that it was obliged to exercise its discretion, given that it had known why DEI was delayed, in the sense that they had issued the variations. They knew all about the delay, they knew all about the reason for it, and the benefit they obtained from it. The situation the court held that the failure to do so would breach an implied duty of good faith, and they should allow a remedy to DDI. But you can see that in these disputes which are going to court, they're substantial disputes, they're costing a lot of money to litigate, and if you can avoid the problem before you start, you end up in a lot better position. So you might now look at exclusion clauses. What are they? How do the courts regard them? And where do they fit in the cosmos that we have to live in to decide our rights and liability? Exclusion clauses generally are interpreted tightly by the court. And that is, if someone puts forward an exclusion clause or is otherwise going to benefit from an exclusion clause, the courts will say we must interpret it very carefully. So if it says that all variation claims will be barred after 7 days, that might not bar a claim for extra work. The courts might say, well, a variation claim is that's got to be varied under the contract procedures. But if you're asked to do some extra work informally outside the contract procedures, then the court might be prepared to say, we'll interpret the exclusion clause so that it doesn't exclude payment for the extra work. So there's a contest, a creative tension between, on the one hand, the court saying you've got to go through the procedures to get paid. The exclusion clause will otherwise knock you out your claim. But if the exclusion clause doesn't, then recovery might be obtained. So the situation is you ought to be careful of exclusion clauses. You ought to be also careful these days of people linking up indemnity clauses with them. So they say, we exclude all information given to you about safety on site, and we require you to indemnify us if anything bad happens to us arising out of safety on site. And while that clause seems all sort of very fine to sign on day one, 2 years later, you can find the indemnity clause having a massive effect in the sense that it sweeps in all sorts of responsibilities and liabilities which weren't previously contemplated. So the answer with exclusion clauses and indemnity clauses is to look at them very carefully, only sign them where appropriate, and make sure you haven't overcapitalised a contracting party that you're contracting through. The other aspect, of course, is with latent condition clauses and clauses generally, you often have pre-negotiated variation rates. So you'll say, well, no, pumping any excess water out will be paid for at $1 a litre, and that pretty okay. Everyone's happy. Everyone knows what's getting paid and what's being paid. But the situation is that there are often complexities in getting the appropriate rates. And one should be careful, as this case says, in determining a reasonable rate to have regard to all the material circumstances, because that can alter the rate that's fair substantially. Take an example of a contract situation I was advising on, and my contractor thought he'd achieved a great feat in his life because he thought he'd arranged to tender and obtain a contract which allowed him to charge for every litre of water he pumped out of a deep excavation. So the situation is that if he only pumped out a small amount of water, then of course he didn't make much money, and probably he lost money because the pumps to set up, etc., would take more than, say, $1 a litre. But in his case, the water rushed in, and it rushed in like gold because he charged gold for pumping it out. And because he could, with the volume of water that was incoming, he could put on a massive pump to pump at a massive rate and make a substantial amount of money. It would have been more sensible to have a different way of calculating the cost, which would have perhaps been referable to the size of the pump and the effort involved rather than just to the litres. Eventually he was able to negotiate a good solution, and he benefited by thinking quickly at the time. The issue of foreseeability and objective measures and subjective tests are always important, and one should be careful because on the one hand, your opportunity, your progress payment might be evaluated in the warm, congenial environment of the site shed, but alternatively, the court's going to look at it in a fairly calm courthouse some years later, and they would have said, well, what is a competent contractor would have foreseen in this event? And they may expect that he has more knowledge than he may. So be careful that when you're considering these aspects, how much risk is foreseeable, how much latent conditions should I allow for, how much site inspection should I do, or industry knowledge and experience should I employ, you should take a conservative approach. The other aspect is you've got to establish causation, even in a latent condition. You hit a latent condition, say you hit rock. You've still got to prove the existence of it, which means you've got to survey the rock and make sure the rock was in the way of the works and therefore caused delay and expense. You've got to show that the condition wasn't foreseeable. That is, that you couldn't have expected it. So you want to go over and show that again, even if it was pretty obvious. And you've got to show that it's caused cost or delay. The concern is you've got to actually show that it had an impact. The concern is, in one delay case I was involved in, the cause was that somebody deposited a load of rocks on the pipeline. Well, the contractor thought that justified a delay claim from when the rocks went on the pipeline to when they came off. But it was eventually decided, perhaps unfairly, that the delay claim only occurred once he had constructed the pipe to the edge of the rock pile and once until the rock pile had gone off, which is a much shorter time. So it's important that you prove the cost and delay involved. Additionally, what you've got to look at is contractual and legal clauses which qualify what you can recover. It's important to go through the contract and prove item by item the requirements of the contract have been satisfied, and that you've got the necessary site records and delay analysis and expert reports to back it up. It's important that latent condition claims are properly proved properly established in order that they be well paid. So, again, we're going over things here to say that reliance was reasonable. The principal had knowledge or failed to give contrary knowledge to the contractor, that the contractor relied on the information he was provided to the extent that he's been led to his disadvantage. And of course, you've got to look at the cost impacts, excavation, traditionally stand-down time, additional plant and equipment, changing of working materials and methods, time impacts, delay the critical path, resequencing, flow-on effects for other subcontractors. They're all got to be specified, understood, proved and quantified. It's important to make sure that you prepare claims in the geotech particularly, but other latent condition claims so that they're effectively waterproof. Looking at those aspects, you want your geotechs to validate the existence. It's not a matter of saying, oh, I hit rock. No, get a geotech to say what rock you hit. Programming experts to show what's happened as a result of that latent condition, and quantity surveyors to assist in the cost quantification. Oftentimes an expert quantity surveyor can prove a level of cost that's substantially above what your site foreman might claim. But you want expert evidence which is independent because it stands the test of time better. You want it based on an objective analysis. An expert to be accepted in court must actually show his reasoning to get to the result. Otherwise, it won't be accepted. And I was involved in a matter where, luckily, the other side fell into the trap. Their expert had a wonderful report, inches thick, and was prepared to stand in the box and support it. But the problem was that all of the facts that he assumed hadn't been proved by other witnesses, and his whole case fell down. So you've got to make sure that it's based on objective analysis, facts that are proved, and it's consistent with the contractual framework. If you're not coming within the clause of the contract, the concern is that you might not recover. Big important aspect for contractors particularly is to comply with time bars. Alternatively, you can always try and wriggle out of time bars, and lots of times you succeed. But the cost of doing it, as opposed to the cost of complying, is hugely disproportionate. If you've got a time bar and you comply with the time bar as good as you can within the time available, you prevent a very substantial discount being applied to your claim. You want to issue early notice, reserve your rights to provide some more information, and make sure that you've provided the maximum you can. So I wanted to just look at another couple of cases, and the situation here is that here was a sale of a hotel, laundry hotels, they're a famous hotel chain, and they signed it pre-COVID for completion in March, and the vendor must carry on business in the usual ordinary way. That is, until it was there. The health orders forced restrictions, take away operation only, and the purchaser argued the clause was breached and the contract was frustrated. So again, you have somewhat an unexpected condition, a somewhat latent or hidden risk that has come to pass. Laundry served notice to complete and terminate. And the issue was, did the vendor breach essential obligations, preventing it from enforcing completion? And the question was, and it was a fairly strong court of the Chief Justice and Mr. Justice Brereton, was essentially inseparable. The business couldn't operate as a going concern. Laundry was not ready, willing, and able to complete. The vendor's termination was repudiatory. the deposit was ordered returned to DICO. So again, the situation is that you've got to be careful. There was a dissenting judge which said the clause is not essential and performance was not was not to be expected. But the situation is the court went the way of the purchaser who got his money back. Again, if you're for a principal, you must draft effective latent condition clauses, and the situation is there, define the latent condition you're wanting to provide for, define the trigger events, how much rock has to be hit before there's a latent condition, set procedures for notification, inspection and entitlement so as you can manage the situations when they arrive in a sensible and ordered way, state how cost and time is going to be assessed, and allocate risks for particular types of conditions. Some conditions might be shared, some conditions might be on the contractor or the principal. The other aspect about latent conditions, if one's running a major project, is to perhaps put baseline site data. Running a major pipeline, why don't you specify what is the expected condition throughout the pipeline? And then as you proceed along the pipeline, you measure the condition by agreement, and the adjustment to the contract price can be made. Contractors' due diligence list. It's important to conduct site investigations, geotechnical and historical site, analyse utility records, have the geotechnical experts pre-tender, and confirm the assumptions and qualifications in your bid. If your bid is that you haven't been able to survey the bottom half of the block, then put your bid qualified as to that. Protect yourself as to what is the risk. The risk often tends and turns out to be much more critical than there. For a principal disclosure obligation, look carefully at providing all the material site information in possession. Identify what site conditions are assumed in design in case they come back to haunt you, and ensure that geotechnical and contamination reports are current, because that otherwise will cause grief. Early detection. If you're a contract administrator, you should look carefully to making sure that you're on top of latent conditions and can manage them from the get-go. As soon as they occur, you've got plans in place to run them forward. Managing claims, you'll need to do the usual things to manage claims and make sure that you're in a state to have prompt notices from contractors, maintain your site diaries, drawings, photographs, have an agreed method for quantifying the impacts. At least have a record of the amount of material that's being carted, either off-site or otherwise. Engage experts, perhaps neutral experts early, in order to understand the matter and maintain transparent and respectful communications. If you're engaging experts, look for experience, independent and court experience. Define the scope that they're to look at. You don't want them running away over all sorts of issues and raising issues that have to be then managed but aren't real. The common pitfalls: failing to give timely notice, incomplete or poor site investigations either before or after you've hit the latent condition, over-reliance on earlier reports which are exaggerated or confused without any validation, and assuming the risk allocation, we'll all sort this out together, without checking the contract and really what's the problem. So you come to an aspect of when to call a lawyer or when you know you've got a problem. So when you can't investigate a site for issues when you're tendering, you've got to be careful to qualify your bid. And when you encounter a latent condition of a type that's of an issue and substantial, and the principal rejects your claim, you need to look at some early advice to make sure you stay in the straight and narrow. So that's what I wanted to cover this afternoon, in order that I could send you away enthusiastic. And I advocate to you to give this area particular concern, particular attention, as it'll inevitably reward you handsomely. Thanks for attending today's talk. It's covered the important aspect of latent conditions. If you've got any residual concerns or issues you'd like to discuss with us, please send me an email for Doyles Construction Lawyers so as we can assist you make your project a success. Thank you.